Hello there once again, and welcome to In Your Corner. I'm your host, John Scholes, along Sivan, Tumarkin, and James Fireman here to talk about a lot of good stuff on In Your Corner here today, guys. Want to have your heads up and your ears open for today. We'll get to 3 ways you can make your long-term disability claims stronger. This is key information. If you're swimming around that pool now, you'll want to have these guys in your corner and giving you all the details. But other than that, basically what the show we talk about every week here, James, give us a basic roundup of what we do.
Sure. The basic purpose of the show is to clear up some of the misconceptions and misinformation that is out there about disability law in particular, so that the people who are watching, if you're disabled, that you're going to understand your rights. And ultimately, if you are getting disability benefits or applying for it, or if you have a loved one who's in that situation, we want to make sure that you or they have their benefits for as long as possible. And if and when those benefits are denied, that you are in the best position possible to challenge the insurance company for their decision.
Want to reach out, by the way, anytime, 1-833-IN-YOUR-CORNER or help@inyourcorner.ca is the email address. We'll try to get some of those a little later on the show today. You got something to talk about, a success story, something that happened recently. What's going on, Sivan?
You know, there are a lot of success stories at the firm, and we've helped a lot of people over the last, few years that we've been, really focused doing the TV show and doing the radio show. And, an interesting conversation that I had just this past week with a good friend of ours. His name is Terry. He is, he has background in insurance. He used to work in the insurance industry for several decades. And, we had a very frank chat about how, insurance companies operate when it comes to long-term disability claims. And he said something that really resonated with me. He called some of their offices profit centers. Nice. It resonated because I'm just thinking about all these individuals out there who've had their long-term disability claims cut off or denied when they should not have been denied or cut off, when these individuals are still disabled, still unable to work. Their doctors are saying that they can't work, and yet these insurance companies, what are they doing? They're doing exactly the opposite of what they should be doing. They're not acting as a safety net. They are cutting people off disability, forcing them, oftentimes against doctors' advice, to go back to work. And this is what James and I are here to do, to educate people, to tell them you have options. Don't be part of that machinery. Don't create that profit for those profit centers for the insurance companies. We can help you combat. We can help you take the fight to the insurance company. And in these kinds of cases where you cannot work and your doctors are telling you cannot work, we can help you force the insurance company pay you what you're owed.
Terry's he's an interesting cat. We got to have him on the show one day.
He's very knowledgeable, and again, on that side, and he's taught insurance adjusters. Right. And we were talking about the fact that some insurance adjusters, they don't care. They don't care. They have a job to do. Their job is to save money or make money for the insurance company, hence the profit center phrase. But there are also good adjusters out there. But again, they have a mission to do, and their mission is not to help you. Their mission is to help their overlord, which is the insurance company, that whole behemoth, that complex that is there for one purpose and one purpose only, which is to make money.
You've mentioned the radio show, which we've been doing for several years. InYourCorner.ca is a good resource to find where you can catch it, the podcast of the show, and past shows of this nature as well. Employment Hour, your partner, Lior, does that show here, and quite often on that radio show we get a ton of phone calls, and some of them cross over between long-term disability, and there's also employment matters as well. So on that show, the ones that have to deal with what you do, those are the ones we farm out for this show. We're going to play one back now, and I know you guys want to comment on it, right?
My wife recently had surgery on her back. There were some complications, and she has to stay off work for a while. Now, she's been on long-term disability for over a year, and now the insurance company is telling her that she has to go back to work in a few weeks, or they will cut off her insurance. She can't go back to work. That's what her doctors are saying. And now her employer is also saying that if she doesn't go back sometime soon, they will fire her and replace her. We really have no idea what to do.
It's almost the same old, right? You've heard the story a million times, heard that record.
Absolutely. So, I mean, first and foremost, you have to listen to what your doctors are saying. They are the ones who are there to provide you with medical advice about your treatment and about your condition. So you don't listen to your insurance company over your doctor. You don't listen to your lawyer over your doctor when it comes to medical advice. I'm not a doctor. Sivan's not a doctor. That's not what we're here for. You listen to what your doctor is saying, and that's who you follow. But if and when your insurer cuts you off, that's when you start a legal claim. You do it immediately. And if they tell you that they're going to do it at a certain point down the road, but they've told you this is when it's going to happen, don't wait. There's no reason to wait. We start it now. We can absolutely help in those circumstances. There's no reason to wait until the date where they actually stop paying you benefits. All that's going to do is delay the resolution, and it means that there's going to be a longer period of time where nothing's coming in.
And don't get wrapped up in that appeals process.
No,
we can't say that enough, right?
God,
No. Don't do this. I mean, I think probably 4 out of 5 people who contact me every day, they tell me that they've contacted us after listening to us on TV or on radio, or someone's told them about us, but they've themselves tried to appeal once, twice, sometimes even 3 times. Don't get sucked into that. This appeal process, there's an illusion there that there's a formality to it, that you have to go through it. You absolutely do not. It's an internal process for the insurance company. And James and I have been talking about this for quite a while now. People think that they have an obligation to do it. In fact, even insurance companies have often come back and said, well, you haven't even appealed. Yeah. To which we reply, well, if our client had appealed, would you have approved? Right? And that shuts them up. Yeah. Because if they say, yes, we would have approved, then why are we here talking? And if they say no, obviously that's the reason. So, do not appeal. And again, talking about the employment interplay with disability, we can deal with those issues at the same time, concurrently. We have lawyers dealing with disability, like myself and James, and lawyers who specialize specifically in employment law, focus on employment law. We can deal with all of these issues and maximize really whatever our client deserves and is supposed to get by way of compensation.
Yeah, and in a situation like this, it's my experience that in virtually all cases, when you tell your employer that despite what your insurance company has decided, your doctors disagree, they say that you can't return to work, that you value your job and you would like to go back, but you can't do so until your doctors give you clearance. And you're challenging what the insurance company has decided by bringing a legal claim. When your employer finds that out, 9 times out of 10, if not more, your employer is going to back off and say, okay, deal with that first, then we'll see what's happening once you get clearance from your doctor to come back.
Guys, we'll take a short break. When we come back, 3 ways to you can make your long-term disability claim stronger. That and what happens when the insurance company introduces surveillance. We'll get to that as well. In the meantime, 1-833 in your corner and inyourcorner.ca. Stick around, lots more to come.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hi there, welcome back to In Your Corner, 1-833 In Your Corner to reach out. Help at inyourcorner.ca is the email address. As mentioned, guys, before the break, I want to get right into the meat of this one. 3 ways you can make your long-term disability claim stronger. So we want to get to that. Number 1, get referrals to specialists. How so?
So that's important, right? Oftentimes people come to us and they have a letter from their family doctor, and there's nothing wrong with a letter from the family doctor saying that you are disabled from working, but you want to bolster that up. If you're dealing with mental health issues, it would be more ideal for you to get a letter or a report from a psychologist or a psychiatrist. And incidentally, that's just from a legal standpoint. I mean, you want to get better. That's ultimately the goal that you have in your doctor's goal, right? So you want to, if your doctor's not referring you to a specialist, whether it's an orthopedic surgeon or a neurologist or a psychologist or whoever it is that needs to deal with your type of illness or injury, you want to press your doctor for that. And that's going to help you not only from a treatment standpoint to make sure you have someone who deals with your area of disability, but also from a legal standpoint. Because if we present to the insurance company when we fight them with a report or a letter from the family doctor who's known you for a while, but also from those specialists, the insurance company are going to be more hard-pressed to deny those claims. Now, they may still deny those, but again, we are looking long-term. What happens if this ever goes before a judge? And again, most of these cases never even see a courtroom. But who's a judge going to listen to? And insurance companies know that. They understand that the more medical expertise, the more firepower we have that we bring to the table, the more they're going to have to pay at the end of the day, and that's why they try to resolve these claims earlier rather than later.
Number 2 on the list, guys, make sure your doctors continue to send reports to the insurer. What kind of timeline are you looking at here?
Well, there's no hard and fast rule. Every case is different, and it really depends on what types of issues you're dealing with and how frequently your treatment and your condition is changing over time. But generally speaking, I like to make sure that my clients provide updated information from their doctors and other healthcare practitioners at least every 3 to 4 months. And in those, not necessarily with every update, but at least periodically, there are reports that specifically address some of the issues that are relevant to disability cases, especially that person's ability to return to work. So that's a general guideline where a situation is developing more quickly, where your condition is changing more rapidly, maybe sooner than that. There are some conditions which are long-standing and are almost never going to change, in which case you might not need to update it that quickly. But the point of the matter is you want to make sure that there isn't a vacuum there, that there isn't a possibility for the insurance company to say, oh, well, look, we didn't have any information, there was nothing updated in our files, so we decided to cut you off. As long as you are taking reasonable steps to make sure that they have all of the relevant documents, then you should be fine.
Is that timeline a good blueprint for the employment side as well? To keep in touch with your employer if you're off?
That's something Lior probably would want to touch on, but generally I would say yes, especially if the employer is asking you what's going on. You know, they want to know.
There's no harm in...
No, there's no harm, but I think with insurance companies specifically, they are looking for any reason, I call it an excuse, to cut you off or to tell you that they're going to cut you off. And people often call us and tell us, listen, the insurance company said they're going to cut us off, or, you know, unless they get X, Y, and Z from the doctor, they're not going to continue paying benefits. You want to make sure that your doctors are sending those reports in. And frankly, even if you have to go to your doctor's office to get those reports, to send those to the insurance company, do that. Do that. It's going to make it that much harder for the insurance company to cut you off, to deny your claim. And if they do that, we will step in and we will fight back.
The third of 3 ways you can make your long-term disability claim stronger, guys, is make sure you comply with all the treatments your doctors prescribed.
So, you know, again, that's extremely important, but for 2 reasons, not just the legal side. I mean, think about that, John. You want to get better if you are disabled. I haven't met a person yet who has been ill or has suffered an injury who does not want legitimately to get better. Now, beside that, you also have an obligation in law to mitigate, which means to lessen or to make sure that your losses are not as great as they otherwise would be. And that means following treatment recommendations. And insurance companies will use that against you. If your doctor says you have to do this or this or this, and you say, I'm not going to do this, this, and this, they will use that against you, and they will have a good argument for using it. I've used that against claimants when I was working for insurance companies years and years ago. Don't be one of those individuals. Now, sometimes, legitimately, you can't do certain things. You can't take certain medications. That's okay. That's absolutely fine, so long as your doctors can explain it and your doctors are on your side. But you want to make sure that you follow treatment recommendations for your own health and for the health of your legal claim.
Now, there are some limits on that.
Okay.
And so, for example, if your doctor has proposed surgery, a major surgery in particular, and it's an optional thing, and the outcome is by no means certain, as is normally the case, it isn't a situation where the insurance company can say, oh, well, you were given this option to have surgery and you didn't do it. No, it doesn't work that way. The law doesn't recognize an obligation for you to take the risk of having major surgery when the outcome could, in many cases, be fatal. That's often a potential risk factor, is death. And if that's the case, it's quite reasonable for you to look at the other options and to treat it conservatively. You make whatever decision is best for you, but your insurance company can't turn around and say, oh, well, you didn't have surgery and therefore we're cutting you off. And if they do that, they're in a terrible position legally.
It's a big difference between that and your doctor saying, hey, how about going to physio twice a week?
Right.
That's reasonable.
Absolutely.
Right. Surgery is completely different, right? You want to reach out to 1-833 In Your Corner. Email as well, help@inyourcorner.ca. We'll get the one from Justin. Justin says, guys, is surveillance legal and what should disabled individuals know about it? What should they do if they're cut off long-term disability because of the results of that surveillance?
So surveillance is legal. It's not at all uncommon. Sivan and I have both worked on the defense side earlier in our careers, and both of us would make use of surveillance on particular cases. There's nothing inappropriate about it, generally speaking. There are limits. They can't interfere with your day-to-day life. They can't go out of their way to make things difficult for you. And frankly, if they're doing good surveillance, they're not going to be seen by you.
Right.
But generally speaking, it's fine and it's part of the process. When my clients ask me about it, I invariably tell them, don't worry about it. Because if you are following your doctor's recommendations, and if when you are asked questions by your doctor or by another lawyer, you are answering questions honestly, then surveillance does not matter. If they have surveillance of you going to the local pool every week to swim for an hour, and your doctor has told you this would be really good therapy for you, you should do this, then it doesn't matter. Who cares? As long as when you're asked, you don't deny that you can go swimming. They might as well have you eating a ham sandwich. It makes absolutely no difference. Right. On the other hand, if you've told your doctor or another lawyer on an examination that you can't get out of bed and you need help to even microwave whatever, and you can't care for yourself, and yet they have you swimming every week, that's a different story. Okay. Yeah. So as long as you're being honest and following your doctor's instructions, does not matter. If you get denied and they say, oh, well, we have surveillance of you, relax. Now, yes, your benefits have been denied, so that's a problem, and you're going to want to challenge that. But just because they've used this magic word, surveillance, doesn't mean that they have a strong case. There are many examples, in fact, most examples, when I see that there's been surveillance. It's at worst going to be neutral. Very rarely have I ever seen a case where the surveillance has shown something that completely upended what my client said their position was. And in those cases, if my client has said that, they have great difficulty getting out of bed and it shows them going to the pool, okay, fine. But in most cases, it doesn't reveal that. It's just very mundane, day-to-day things. And in some cases, it really proves my client's case. Because right? I'm always going to find out, how long did you hire that investigator to conduct that surveillance? How many days were they out there with their video camera trying desperately to find, just a moment where you're doing something that you shouldn't be doing or you say that you can't? And what did you find in those 40 hours or 60 hours or 70 hours? And you take a look at it in that context, and far more often than not, it helps your case.
Wow. It works out. We've talked about that before. It's like the insurance company's always like, damn.
Yeah, and it's expensive for them.
Yeah.
I mean, the fact that they do it doesn't mean that they do it lightly.
Yeah.
But James is right. If you have been denied or cut off disability because they say we have this great surveillance on you, it's more of a psychological weapon. It's to dissuade you from challenging them.
Being watched.
You're being watched, or we have this on you. Yep. Give me a break. And adjusters know this, and defense lawyers know this, which is why, despite surveillance, they still come to the table and they try and settle these claims.
Coming up, what to do when your insurance company says you're not, first time I've used air quotes, totally disabled. We'll get to that after a short break. Reach out, 1-833 In Your Corner and inyourcorner.ca as well. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hey, welcome back to In Your Corner. We have given you plenty of ways to catch up and contact as well. Help at inyourcorner.ca. 1-833-IN-YOUR-CORNER is the phone number. There's also mydisabilityquestions.com. Sivan, James, I know you guys love this website. It is a place where you can ask questions and have them answered quite swiftly. We'll get to one from it. It says, my mother underwent chemo for a rare form of skin cancer. The insurance company says that her 2 years are coming up and that it's time to return to work. How many times you heard that? She's still very sick and her job as an executive is quite demanding. Her doctors told the insurer that she's not ready to return, but they already set the date for her to stop getting payments. How can we stop them from cutting her off?
Okay, so first of all, if they've set the date of when your payments are going to stop, in a few weeks, in a month, 2 months, whatever it is, and you are not ready to go back to work, and your doctors are saying that you're not ready to go back to work, we can take action now. We can actually push back on the insurance company now. That's called anticipatory breach in legal lingo. Now, what's important here to understand is that this person who's writing to us says that the insurance company says that she's now reached that 2-year mark. And I think it's important for our viewers to understand what that means. In the LTD, long-term disability context, the way, or what you need to do in order to get disability for the first 2 years is you have to meet the own occupation test. You have to be able to demonstrate with medical support that you cannot do your own occupation, right? So if you are a TV host, you have to show that you cannot be in that job. That's how you get LTD. But beyond the 2 years, the test changes. It now becomes any occupation, from own occupation to any occupation. It means that you can't do any occupation for which you are suited for by training, education, or experience. So no one's asking, John, if you'd be able to go and become a barista. That's not the issue. It's whether or not you can do something that you're trained for, have experience in. Okay. Now, in this particular case, clearly this lady is unable to go back to work. Clearly there is medical support. I mean, we're dealing with cancer here. Everyone knows the gravity of cancer. There's absolutely no reason why the insurance company is taking the position that she should have to go back. But here's the pitfall, and many people fall into it. What happens is that individuals believe that they have to try to go back to work against medical advice, which you should never do for health reasons, but also for legal reasons. Remember, John, if you go to your doctor and you say, doctor, please give me a note that says I'm able to go back to work, what's going to happen? Most likely you're going to go back to work, you're going to fail because you're not ready to go back. Your doctors have told you that. And then you try to go back on disability, except that now the insurance company turns around and says, hey, wait a second, we have that note from your doctor saying you're ready to go back to work. So you don't do that. As soon as something like this happens, you do exactly what this lady did. Contact us. Let us help you. And here's what we're going to do. We're going to tell you, do not go back to work. Let us communicate and deal with the insurance company now. We will start a legal claim right now, and we will resolve that claim. The last question here, how can we stop them from cutting her off? You can't stop an insurance company from cutting you off, but you can put yourself in the best possible legal position to fight back. Don't take that at face value that they're telling you you have no options, you can't do anything, you got to go back. Absolute nonsense. You can push back. We can help you do that. And we should help you do that because that's how you're going to get the compensation, the money that you are owed, that the insurance company wants to keep for themselves.
Questions, mydisabilityquestions.com. That's where we got that one and this one as well. I'll throw this one to you. James says, I'm a 46-year-old database analyst, just diagnosed with lupus. I had breast cancer in 2014 that led to a double mastectomy and then developed depression and arthritis. I have 3 doctors that all say I can't work because of my conditions, but the insurance company says that I don't fit their definition of totally disabled. There you go. What does this even mean? I feel completely lost right now.
Well, at the top of the show, John, we talked about what we're trying to accomplish. And one of the things we're trying to accomplish is to break down some of the misinformation and misunderstanding that people have about disability insurance. And this is a perfect example of that. So if you want to know what totally disabled means, what you need to do is you have to get a copy of the policy. Now, most people don't have a copy of the policy with them, but if they did, in the first couple of pages, there would be a chart of definitions, and it would have what each of those terms means. And one of those terms is totally disabled. And this is what Sivan was just talking about. What totally disabled means in the first 2 years is that you're unable, because of injury or impairment, to return to your own occupation. Totally disabled changes after 2 years to mean any occupation. That is all it means, nothing more, nothing less. It's that simple. But they call it totally disabled, and in doing that, there's some significance that people attach to it wrongly. Other policies might just call it disabled. It doesn't matter. There's no distinction between a policy that says totally disabled and another that says disabled if the definitions are the same, and they almost always are. They could call it gummy bear. It doesn't matter. It means whatever is defined in the policy, and all it means is that you're unable to return to your occupation. So why do they call it totally disabled? Because it has a particular meaning, and people think, oh, well, if it's totally disabled, that means something more. And so they get a letter from their insurance company saying, you're not totally disabled, so we're denying your benefits. And they think, well, gee, that's right. I'm not totally disabled. I mean, I can do some things. I can't go to work, but there are some things that I can do. No, that is not what totally disabled means. Totally disabled means exactly what it says in the policy. No more, no less. If you can't return to your own occupation, then you are totally disabled under the policy. So what can we do? We can start a claim and we can challenge it. And they know that. And when they deny for those reasons, it's usually a case where they're in a worse situation where than in another situation where they perhaps don't have the medical evidence, where you haven't given it to them. So in this sort of a situation where they say, oh, you don't meet our definition of totally disabled, if you have support from your doctors, if your doctors are saying that you cannot return to your own occupation, then you meet the definition.
Those are two scary words, totally disabled. We've talked about this on the radio show. It seems like, I've got to be in a complete coma, or like you mentioned earlier, the late Christopher Reeves, like that's to most people, that's totally disabled. They can't function at all.
It's a tactic. It's a tactic. It's a tool. James is 100% correct. I don't care what the insurance industry is going to say. They could have used the term disabled. They didn't have to use the term totally disabled. Right. Someone had to pick that word totally because it gives you an image. And the image is that you have to be totally disabled. What does that mean? It doesn't mean what you think it means. And, that's not just individuals out there who are struggling with this. It's also practitioners. It's family doctors. It's specialists, psychologists, chiropractors, whoever it is. When somebody comes to them and says, the insurance company says, I'm not totally disabled, a lot of these individuals are going to have the same reaction that the ordinary person does, which is, yeah, no, you're not totally, you're disabled, but you're not totally disabled. Again, people need to understand that that's not what it means, exactly as James said. And frankly, when an insurance company denies a claim on that basis, when there are doctors saying this person cannot work, those are the cases where the insurance companies bend over backwards to try and resolve claims once we start that legal process.
Sivan, I know you got some final thoughts on this and some other things, but I want to try to squeeze in a quick email here in a minute. Brian writes in and says, do you have to follow the treatment plans of the insurance company's doctors? And what if your doctor agrees that the treatments are not good for you?
I think that if your doctors are telling you that the treatments that the insurance doctor is recommending are not good for you, you follow what your doctors are saying. And there are exceptions to the rule, of course. I mean, and sometimes it happens that the insurance doctor gives you recommendations that your own doctors agree with. Well, then you can't ignore these. Again, it goes back to the earlier point of you have an obligation by law to try and get better. It's also in your interest, medically. But if your doctors are telling you one thing and the insurance company is telling you something else, my advice would be follow what your doctors who know you, who have your best interest at heart, follow what they're telling you.
Final thoughts. What do you think, pal, for this week?
Yeah, John, I want to address the audience directly on this, and I want to talk about statistics. According to Statistics Canada, more than 40% of Canadians have severe or very severe disabilities. Almost 1/3 of Canadians who have severe disabilities live in poverty. And here's the thing, insurance companies keep statistics as well. Remember, we talked at the beginning of the show about profit centers. Don't become a statistic for the insurance company. If they deny your claim unjustly, or if they cut you off unjustly, your doctors are saying you cannot work, don't just take it. Don't walk away from money that is owed to you. Give us a call, email us, let's have a chat. Let us tell you what your legal options are. I promise you, you're going to lose nothing by it, and then you can decide how you want to proceed. But don't become a statistic for the insurance company.
Great stuff today, guys. We'll wrap it up. Again, contact, now that we're done for this week, 1-833 In Your Corner, help@inyourcorner.ca. You want to find out where you can catch the radio show or past shows of this particular nature. That's simple as well, inyourcorner.ca. Please join us again next time.